This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance, explaining why if there is no coverage for benefits under a contract of insurance, there can be no right to bad faith damages, regardless of how the claim was handled, and why the concurrent cause doctrine requires the parties to segregate covered from non-covered losses, and if they cannot, there can be no coverage for a claim. Landmark Partners Incorporated and sued Western World Insurance after it denied Landmark's claim under an insurance policy. Landmark asserted claims for breach of contract, statutory violations, breach of common law duties, and attorney's fees, and statutory interest. Relying in part on the testimony of Landmark's own expert, Insurance moved for summary judgment on the ground that the concurrent cause doctrine defeated Landmark's contractual claim, which in turn defeated Landmark's other claims. The trial court granted summary judgment for Insurance, and Landmark appealed. In Landmark Partners v. Western World, a December 28, 2023 decision of the Court of Appeals of Texas, the Court of Appeals applied the concurrent cause doctrine to resolve the dispute. Landmark's policy with Insurance covered damage to Landmark's commercial property, but only for damage that combined and commenced during the policy period, which began on February 4, 2020. The policy included coverage for hail and wind damage, but no coverage for rain damage to the property interior unless the rain entered the building through damage caused by a covered event. After a storm on May 7, 2020, Landmark filed a claim with Insurance requesting that Insurance provide coverage for damage to Landmark's building, which Landmark alleged had been caused by a storm. Insurance sent a contract field adjuster to inspect the property, and that adjuster reported no signs of hail damage on the property's roofing material. Landmark hired a public adjuster who disagreed and put in proof for more than $1 million. Insurance then retained an engineer, Jared Burns, who did find some hail damage, particularly to some mechanical units on the roof, but he determined that the damage had been caused before the policy took effect. Therefore, Western World Insurance denied the claim, and Landmark sued for failing to provide coverage. Insurance filed a motion for summary judgment based on the concurrent causation doctrine, which applies when covered and excluded events combine to cause an insured's loss. If both covered and uncovered events combine to cause a loss and the covered and uncovered events are inseparable, then causation is concurrent, the insurance policy's exclusion applies, and the insurer owes no coverage for the loss. Covered damage to the property could not be segregated from non-covered damage, and therefore the Court of Appeal concluded that the trial court signed a final judgment granting summary judgment for Insurance, and Landmark, of course, appealed. Because an insurer has no obligation to pay for damage caused by an event not covered under the policy, if covered and non-covered events combine to cause damage, the insured must segregate between the damage attributable to the covered event and the damage attributable to other causes. Thus, Landmark would have to show at trial one of three circumstances. One, that the damage had only one cause, which was covered by the policy. Two, that the damage had multiple independent causes, one of which was covered. Or three, although covered and non-covered events combined to cause the damage, Landmark had segregated between the covered damage and non-covered damage. Landmark had the burden to show that the damage for which it sought coverage resulted from the May 2020 storm or another covered event. If Insurance's summary judgment evidence established as a matter of law that segregation was impossible, Insurance was entitled to judgment unless Landmark responded with evidence raising a fact issue. because insurance's summary judgment evidence established that any damage caused by the May 2020 storm could not be segregated from the damage caused by previous storms that were not covered, insurance demonstrated it had no obligation to pay under the policy, thereby negating Landmark's breach of contract claim. Since Landmark failed to segregate between covered and non-covered damage, or even raise the possibility that segregation could be done, under Landmark's evidence, the covered and non-covered causes of property damage could not be segregated. Because Landmark's evidence did not raise a fact issue sufficient to defeat summary judgment on Landmark's contract claim, the Court of Appeal found no breach of contract. But Landmark didn't stop there. It sought extra contractual claims because in addition to its contract claim, Landmark alleged violations of the Texas insurance codes and breach of common law duty of good faith and fair dealing in the context of processing and payment of insurance claims. The Texas Supreme Court has explained an insured cannot recover any damages based on an insurer's statutory violation unless the insured establishes a right to receive benefits under the policy or an injury independent of a right to benefits. As for Landmark's common law bad faith claim, that too was negated by summary judgment evidence, and having overruled Landmark's 5 issues, the Court of Appeals affirmed the trial court's judgment. In my opinion, without a right to benefits of a policy of insurance, there can never be a right to bad faith tort damages. Landmark failed to establish a right to the benefits of the contract of insurance because it could not segregate covered damages from damages that preceded the policy. No coverage, no right to claim bad faith damages for improper claims handling. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and you will be provided with notice of every blog posting, usually 5 a week, sometimes 6. You'll also have access to the more than 4,700 blog postings. You can also subscribe to the videos on rumble.com and youtube.com, and if you do, I'd appreciate it if you click on the like button on YouTube and the thumbs up button on rumble.com. Please also tell your friends and colleagues about the blog so that they too can subscribe to the blog and the videos. This video was adapted from the blog posting. And if you're interested in further information about insurance, insurance law, insurance claims, and insurance fraud, please consider for a very small fee subscribing to my Substack publications. And please also watch and read my postings on X at bzelma. And if you do, please subscribe to my posting or follow my postings on X. Thank you for your attention.